Hey everyone, Angela Langlotz, trademark and business law attorney here, back with another Facebook Live about all things trademark. Yesterday, we talked about a trademark kerfuffle in Trademark Wars, and we talked about Kylie Jenner versus Kylie Minogue, and we are back with more Trademark Wars. All right, so we're back with Kylie v. Kylie. Yesterday we talked about how close you can get to somebody else's mark without it being confusingly similar. Now, we don't know how this case turned out because it looks like the negotiations that settled it were private, but we do know some allegations were made that were a little bit nasty. Among other things, Kylie Minogue, who is the senior mark holder and the one that holds all the cards in this case, being the senior mark holder, is opposing Kylie Jenner, the young cosmetics mogul and member of the Kardashian clan. For those of you who've been living under a rock for the last 10 years, the Kardashians are a famous reality show TV family. I'm not sure if they have any redeeming qualities at all, but in this case, one of their clan is serving as a trademark case study, so at least they're useful for that. So one of the things that Kylie the elder, Kylie Minogue, asserted in her opposition to Kylie Jenner's trademark was that there was some possibility that Kylie Minogue's trademark would be diluted. And what does that mean? Not diluted like you're delusional, diluted like what happens when you add water to something, diluted. So dilution happens when you have a famous mark like Kylie Minogue asserts that she has a famous trademark for music services, performances, and a whole bunch of other things. And since she is a famous persona and she is well known, it's kind of hard to argue against that. But dilution happens when there is a blurring of an established brand identifier, in this case, the trademark identifier being Kylie, which is owned by Kylie Minogue for a whole bunch of things. And this dilution whittles away at the brand identity of the senior mark holder. Among other things, Kylie Minogue asserts that allowing Kylie Jenner to have rights to the trademark Kylie for promotion services and advertising services will tarnish her brand, since Kylie has said apparently some things that disturbed the African American and disability rights communities, and Kylie Minogue doesn't want to have anything to do with that because she's a noted humanitarian and she doesn't want her brand sullied by the younger Kylie Jenner and her somewhat, I guess, unsavory activities, or so it's alleged. So the unflattering publicity that Kylie Jenner has received may rub off on the Kylie brand, which is unfairly prejudicial to the senior mark holder, in this case, Kylie Minogue. The trademark law, also known as the Lanham Act, provides for injunctive relief, meaning we can tell you to stop, against any use of a famous mark, like Kylie, that causes the famous mark to be diluted by tarnishing or blurring. So the moral of the story is, if you are going to have a brand that's anything close to a famous mark, be aware that you may get a cease and desist letter or opposition to your trademark from the senior mark holder if your mark is approaching a famous brand. So hint, don't do that. This is Angela Langlotz. You can find me online at TrademarkDoctor.net. If you go to my Facebook page, facebook.com/trademarkdoctor, you can see a whole series of videos about trademark law, and you can send me a comment and ask me any questions about trademark law, and I'll answer them on a future live. If you like my business page, you'll be notified each and every time that I go live, which is whenever I feel like it, every weekday here in Dallas, Texas. So I will see you tomorrow.